Welcome to Inside Safety, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in workplace health and safety law and practice.
Hello and welcome to the Inside Safety podcast, a podcast for health and safety, legal, operational and executive professionals discussing all things work health and safety in the Australian jurisdiction. Hi, my name is Steve Bell. I'm the managing partner of the Employment, Industrial Relations and Safety team here at our newly branded firm, Herbert Smith Freehills Kramer. And I'm a practitioner in health and safety law and have been for the past 20 years or so. And I'm really excited about today's session. We're going to talk about something which is really contemporary for us and something that is part of our day-to-day lives as we assist our clients working through compliance at the officer level. And I'm here today with two good colleagues and friends. I'm here with Aaron from our Brisbane team.
Yeah, thanks, Steve. I'm excited to be here and have this discussion today. So Aaron Anderson's my name, and I'm a partner in the Brisbane office of Herbert Smith Freehills Kramer and focusing particularly on the area of health and safety.
Thanks, Aaron. And all the way from the west, who joined with Olga.
Great. Thank you for having me. Really great to be having this conversation with the two of you. Olga Klimczak from the Perth team of HSF Kramer.
We're getting used to the new brand, but we will make sure we don't forget and just call ourselves Herbert Smith Freehills. Having merged with a US law firm, Kramer 11, it's really exciting for us. We've now got a much larger global footprint, and we'll bring you some insights from across the Atlantic later in the podcast series. But for today, and actually for the next podcast, we're going to dedicate two podcasts to the question of officers and directors' duties. And of course, that's two different ideas, and we'll talk about boards and we'll talk about officers and executives as we sort of travel through. In the Australian market, we've had the model work health and safety laws in most jurisdictions. Sorry, Olga, we did come late to WA, but in most jurisdictions now for about 10 or 11 or 12 years or so. And one of the sort of jewels in the crown of the change that was made when they introduced the model work health and safety law was to introduce a positive duty of care on corporate officers to exercise health and safety due diligence, to be satisfied that their business is in fact complying with its health and safety duties. This was a real change. It used to be a more passive obligation in the Victorian model under occupational health and safety laws. The law is attributing the conduct of a company to an officer, a really clunky sort of legal model. And the thing that changed with the model health and safety laws was to move to this positive duty. You have a responsibility, whether or not your company complies with the act or is proven to have breached it. As an officer, you've got a responsibility to exercise due diligence. Now, in our day jobs, we talk to boards and we talk to executive teams a lot about this. And when I, summarize for them, what is the obligation of you as a senior leader in the organization? It's really these sort of 5 questions. First, you should have some clarity about the nature of the operations of the business. You need to know what the critical risks are. Second, you need to have a sense of what the controls are. What are the things that we need to do in a repeated way to manage fatal and catastrophic risk in the organization, to manage serious risk out? So those first 2 elements are the stuff of, knowledge. You've got to know the business. You've got to understand what the system requires of people working within it. The next 2 are the stuff of executive leadership. Are we applying the right resources to do what we can to manage risk in the business? And do I think that what we're doing is effective? It's about measuring you against a standard that you set for yourselves as an organization and against external standards. That's the stuff of leadership, if you like. And then the 5th element, is the question of verification. What am I doing in my day job that verifies what we're being told by the management team is right and what we're doing is effective at genuinely managing risk in the organization? So those are the 5 sort of elements of due diligence. There's obviously an interplay between the corporate system, the governance around health and safety, the reporting that's received. And so it can be both simple and complex in terms of its execution. Now, what's happened in the last little while is we've had some case law which has given us a bit of an insight as to where the boundary is to be drawn, and this kind of perennial question of when do I know I've met my duty? When do I know I've done enough? So Aaron, we had something in Queensland recently. What was the story there?
Yeah, we have, Steve. So there was a case that was handed down in Queensland involving a Walshaw defendant. And Walshaw was a managing director, so someone who's clearly an officer and has the duties of an officer that you've just articulated. Now, why we want to talk about this case today is because it seems to be the first case in Queensland, at least, whereby an organisation of a reasonable size has been involved in a prosecution where the director is also charged.
And that's not always the case, is it? There tend to be prosecutions of the director was the guy on the forklift or was the woman on the factory floor? It's not a governance question, it's an execution question.
Quite.
Yeah.
And everyone probably recalls the first charge in Queensland that got a lot of publicity was
Yeah.
an industrial manslaughter charge against a corporate body. And the directors were charged with reckless conduct under a Category 1 offence, you know. And so that was a case where the directors knew that people operating forklifts at a wrecking yard weren't licensed to do so.
Yeah.
So, of course, that's a failure to discharge the due diligence duty, Steve.
Yeah.
So,
But it's about having eyes on the risk. I mean, that's not a governance question. It's just they chose to be aware of and not do enough. But what's changed, I suppose, in this case is it's gone to a slightly bigger company. So.
Well, that's right. And I think the importance of this case, it sort of turns our mind to what sort of reasonable steps means. So, you know, we talk about the obligation itself. So the due diligence obligation sits in the law. It outlines sort of 6 steps you've got to do. And Steve, you've given a bit of a summary about that today, right? But the law is individual, so it's on each and every officer. But really, really important part of the test is that you've got to take reasonable steps, right, to discharge the legal duty. And so I think that reasonable steps is something that is somewhat unknown. There's very little jurisprudence. And so that's why it's important that we talk about it.
Yeah.
And so this case, factually very simple, involved a failure of a zip line in far North Queensland. And tragically, someone was killed and the person's partner was severely injured when the zip line came free because the clamping mechanism of the zip line failed. The company was charged and was convicted of the charge. And the managing director was also charged as an officer. And the charge against the managing director really was that the managing director needed to make sure that the organisation put in place, through the provision of proper technical advice and oversight by management within the company, of systems to ensure that during the construction of the zip line, that the clamping mechanism that was used was appropriate so the failure wouldn't occur. Okay, so
that's quite a technical ask, isn't it? That's not a generic governance question. That's you should have had a view about the technical specification of this thing and be satisfied.
And that's the really important feature of the case. It's a lot, Steve, because suddenly we go to this concept of knowledge, and everyone talks about knowledge. But when we talk about knowledge, what actually are we talking about? Are we talking about knowledge generally about a safety management system and its adequacy within the business to manage the risks that the business is confronted with on a day-to-day basis?
At a systems level.
At a systems level.
Compared
or are we talking about here very specific knowledge?
Mm.
All right. What does the duty actually mean you have to do as an officer?
Yeah.
You know, we had the decision of Ritchie many years ago where the court made a finding in New South Wales about an officer having to have specific knowledge of a product that was used to clean shipping containers, and that caused a few rumptions amongst safety lawyers. And now in Queensland, you know, only a short while ago, we've got a regulator saying you've got to have very specific knowledge about a construction methodology. Can that possibly be right? The good news is this, if you're an officer, okay? The good news is the officer was acquitted.
Yep.
And just some key learnings that came from the case is that reasonable steps means you can place reasonable reliance on senior people in your business, right, to carry out operational aspects of the business, i.e. in this case, manage the construction of the zip line, provided, right, in relying on others to do that, that you have some knowledge about their competence and capability to do that job. And here it was really, really clear that the operations manager who had the role of overseeing the construction and had access to engineers and had, in fact, some technical capability themselves in relation to zip lines was the very person in the organisation who could make decisions, collaborate with others to ensure that the zip line was constructed quite properly. And the court in this case, Steve, said, look, it would not have been reasonable steps for the officer to have stepped in and did anything really in this case other than have a conversation with the operations manager, understand whether there are any hurdles to success. And in this case, that was a really important feature. There were conversations, there was reporting about how well things are going.
Isn't it interesting about the need to be able to prove you've done those things when you hit the pointy end, when you're in court, having evidence that you've actually done that reasonable inquiry and you've got a response. And that's, you know, something to think about, I think, the directors.
It sort of is, right? And I think that's a bit of a lesson too, because people have lots of conversations, whether in the boardroom or around the executive table, or even on an ad hoc basis, like no doubt's occurred in this case. We as lawyers, 3 years down the track, when suddenly you're faced with the prospect of defending an officer in court, you know, you really do need to see the evidence. So, you know, sort of documentation and recording sort of the questions that are raised and how you're challenging and testing what's going on in the business, I think really is an important feature of where we're going. So a good case.
So director acquitted. In this case, could prove they'd done enough. Court said anything else was a bit much, was beyond the pale.
Beyond the pale, and in fact would not have been a reasonable step in this case for the officer to have taken.
All right, now hold that thought. we go across the Tasman. Is that right? To New Zealand?
To New Zealand.
I'm just going to check it is the Tasman. We'll fact check that after the podcast. So New Zealand, tell us about the Port of Auckland's CEO prosecuted under similar laws.
That's right. So New Zealand does have very similar laws and similar circumstances in terms of a CEO was charged. So the organisation is a port, and at the port there were people called lashers, and they were lashing and unlashing the cargo. And this situation involved an exclusion zone. Now, exclusion zones, forklifts, we all know these are very common hazards that particularly have the focus of regulators. The two gentlemen that were working on these containers were in the exclusion zone of a crane, which was active and lifting some containers. There was a clip in place that shouldn't have been in place. So when the crane operator lifted the containers, realised there was something wrong, but before they could put it back down, the container slipped because of the clip and sadly crushed one of the relevant workers. Now, interestingly, I think here the CEO was charged and was found guilty. So this is interesting.
It's sort of seismic in its own way. I think organisations that we advise have always known this is a genuine obligation and risk. And, you know, we're proud, I think, of our client base that they want to do well and they want to lead on safety. But there's always been this question of, well, is this something which is going to attach to a leader of a major company like a Port of Auckland, one of the largest businesces in New Zealand? And
that's right.
So here we are. So now we know what the standard looks like.
That's right. And I think, you know, the trajectory of the prosecutions in Australia have been towards there, but, you know, haven't really got to the point of a guilty verdict yet. Often we have seen the directors being the operational individuals. And there's a lot of directors and officers of major organisations who don't have that day-to-day operational experience. And the question is, you know, what is reasonable reliance to Aaron's point? Now, what the two key sort of failures that were alleged against this CEO was that he was aware of the exclusion zone issue as a hazard and had actually taken steps for a technological solution, but hadn't applied his minds to other interim controls, other non-technological solutions. So here you have the distinction, I think, being that you're aware of a hazard, you're on notice. Now, you know, when you're on notice of something, when there's a red flag, this is a key point for directors. You need to ask questions and you need to think about, well, there is a hazard in the organisation. How is it being controlled? There might be a future control, but, you know, how is it being controlled now? And the other key failure was in terms of the system. So there was a system in place that required that certain reports be issued. And in the last 2 years prior to the incident, those reports hadn't been prepared and issued. And again, you know, this is a situation where you're on notice that something is to occur and you haven't done it. So not a situation where, you know, you're not on notice of the issue because, you know, you've asked the question, you've been assured. But where you actually have notice of something not happening. And I think that's the key, is asking the question, being assured is the key role of the director, that assurance piece and being proactive about it.
Olga, I feel that the Gibson case in New Zealand really highlighted a bit of a focus on where are my blind spots. Because what was really interesting, the incident happened, I understand, on a night shift. And, you know, there's a bit of criticism around what sort of indicators were put in place from a reporting perspective around the way work is done when the management aren't there. And I think that was a really important lesson. So where are the blind spots for officers? How do we identify those and how do we fill that gap by, you know, questioning in an ordinary way?
Couple of things struck me from that. A couple of things struck me from that case. I'm interested in your thoughts. The evidence, I think, was this incident occurred in 2020, let's say. I think in 2018, there'd been a KPMG report which had said in quite specific detail, these are the things that need to be addressed in the business. And I think there was a critical risk review or something or other in 2019, which sort of reaffirmed the following. So we have these breadcrumbs of, precisely your point, you know, alerting the business to the need for improvement. And they get caught in the gap, and now someone lost their life in the gap. But more importantly, the organisation, or not more importantly, but as importantly, the organisation now is asked the question, well, what did you do to fill that gap, to stop that consequence? And it's a really tough place to be, just in a moral sense as much as a legal sense. You know, what more could we have done? And you can imagine the impact of that on the business.
That's right. And I think the issue around vulnerabilities of the individuals or vulnerabilities within the organisation. So typically we do see incidents occur on night shift or with individuals who haven't been working that long. This worker had only been working for the organisation for 6 months. Often that's the case. They're brand new workers. their casuals or their contractors,
Yeah.
The insecure work. Those are the gaps that I think the questions should be asked by directors.
Yeah.
How are these issues being dealt with by
Yeah.
management? And I think to your point, often, there are issues that are, in train and you're aware of them. And there may not be an immediate solution,
No.
but the question is, what are those interim controls? How do we make sure that there are things in place? So one of the key interesting things was that this was actually post-COVID. It happened in 2020,
Sure.
or during COVID, really. And they'd previously had a supervisor, and they removed that supervisor role. So sometimes that change management piece is another area where we see gaps arise. You remove something out of the system. Well, is that going to have an impact on safety? I think that's a key.
And you can imagine the honest regret, in the organisation as they think about this consequence and what's happened, putting aside the law almost and putting aside the judgment of, courts in New Zealand. One thing that was interesting to me from the New Zealand case was there's a reference to a New South Wales decision that came out around the same time on directors' responsibilities, a case where a gentleman's name was Mr. Dobell, and he was an executive officer of an organisation that had been involved. The facts I'll breeze over, but involved in an incident involving serious injuries following a forklift incident. Personally prosecuted and acquitted on the basis that a bit of this, a bit of A, a bit of B, a bit of, there was a safety team, the safety team had reported to him, so what more is it he could have done in his role? Which the New Zealand court says they cannot reconcile that the brevity of that engagement he had with the safety team with meeting what's an onerous duty. So we sort of get a gap here between, what this judgment is telling us and what the New South Wales court found. And I suppose importantly, to not take too much away from this New South Wales decision, it was clear that there was criticism of the way that Safe Work New South Wales had expressed what he ought to have done. The counterfactual, what we would call the particulars of the charge. If he had done the following, he would have met his duty. He didn't do it, therefore he breached his duty. The court said that was a bit of a muddle, and so he got acquitted. So there's kind of data sets here that I think are moving us beyond it's only the forklift operator director who's in the gun to larger enterprises. Regulators are going to have to get clear as to what the expectations are. When you've got evidence that tells you you've got a material risk, you do something about it. But if you can prove that you did what was appropriate or adequate in the circumstances, you may have met your responsibility. And that's the challenge. Now, can I say this? I don't think reading a TRIFA report helps you with any of this. I think numbers and statistics in board reporting do not help you get to the bottom of any of these questions. And that, I think, is part of the education and the evolution of the way in which boards in particular need to be thinking about these issues. And we'll come to that in our second podcast as we unpack that. Just before we break, Aaron, you and I were the Australian Institute of Health and Safety conference on the Gold Coast. And we heard from one of the state prosecutors, and I just thought one of the stats was interesting from the Queensland prosecutor. What did they tell us?
Yeah, it was really interesting. So look, Simon Nicholson is the WHS prosecutor in Queensland. So for non-Queenslanders, the way that it's set up is there's a prosecution office specifically established to consider cases and bring matters before courts. And so it is Simon Nicholson currently in Queensland who has that role. And Simon got up and gave us an interesting sort of insight into the way his office works, and quite equally some statistics in terms of, just the number of prosecutions that have been brought over the last few years. And what was really interesting, one of the recent statistics was over a 12-month period, there are about 160 odd prosecutions that were brought, which I thought was, a fairly significant number. But out of that, Simon divided up sort of where those prosecutions are being laid in terms of duty holders. And out of the 160 odd, there were about 22 from recollection, Steve, that were in fact charges against officers.
Yeah.
So it sort of occurred to me at the time, and I know you and I had a conversation about this, that it seems to be a reasonably high proportion of charges against officers in Queensland. Particularly if you go and sort of look back, these laws have been in place for quite a period of time. It's not clear in exactly sort of out of those 22 what the composition of the organisation is in terms of how large it is or how small it is. But it certainly indicates, I think, that there's a high propensity in the right case for the prosecution office to lay charges and to call officers into account for their conduct when it comes to, incidents, particularly serious incidents that go wrong. So, look, it's a statistic, but it's certainly something that, as I said, highlights the fact that we are now moving beyond just sort of a focus on organisations to individual conduct.
Thanks, Aaron. Yeah, it's a call to arms, I think. This is not an obligation which is a paper obligation. This is a real thing. The regulators are proudly I think, saying that these are the focuses for their officers. That's 15%, let's say, of their prosecutions are at senior leaders. That's worth knowing in an environment where there's a spike of prosecution activity, even in WA, embracing the new laws. Look, thanks, Aaron. Thank you so much, Olga. We're going to come back. So there'll be a second session where we're going to talk about some of the practicalities. If this is the state of play, if there's a heightened set of expectations, if more is needed, how do we help businesses kind of think this through? And we're going to share some stories of the ways in which we talk about this for our clients and some of the investigation processes we've seen. But thank you. Thank you for joining us again for Inside Safety. Please follow this podcast on the service that you subscribe to. And we look forward to seeing you again. But thank you for joining us.